Hey everybody, Jonas Callis of the Hurt at Work Workers' Compensation Law Firm. Many of you may know me as the Workers' Comp guy. First, the obligatory disclaimer. The following is for informational purposes only and does not constitute legal advice to anyone or create an attorney-client relationship with anyone. In another video that I've done, I discussed the basics of what an injury by accident is in the context of Virginia workers' compensation. With this video, I wanted to kind of supplement that video and add some more examples and just to discuss it a little more in depth to help everyone develop a more in-depth understanding of what constitutes an injury by accident in Virginia. So I guess the best way to do it is just to rehash what the definition of an injury by accident is. It's an identifiable accident that occurs at some reasonably definite time, which incident arises out of the employment and in the course/scope of the employment, causes an obvious structural or mechanical change to the body, and has a causal connection between the incident and the bodily change. So, and the biggest issue, often the most heavily litigated issue is the arising out of requirement. And if you've read my website or listened to some of my other videos, you know that the arising out of requirement is simply, it's a requirement that the accident have some sort of connection with the risk, with some sort of risk or hazard associated with the employment that the injured worker was performing at the time of the accident. So, and we talked about how simple acts with nothing more, such as walking or turning or bending or walking down or up regular normal stairs, probably are not compensable in Virginia because it's not really arising out of the employment, because people do that kind of stuff everywhere. Now, we kind of left it. It was a very basic video the last time, and my website gets into it a little bit more, but there are exceptions to the arising out of requirement because it can sometimes be kind of harsh. So, for example, what would if an accident and the resulting injury has to have some sort of connection to the work being performed by the employee, what would you expect of someone who maybe takes a bathroom break and slips and falls in the restroom while on a 5-10 minute bathroom break? I mean, really, what is the connection to the employment? What employment related task were they performing at the time of the slip and fall, right? So arguably that should be not compensable in Virginia, but that's a pretty harsh result, right? Because we're people and people have to use the bathroom sometimes. So and the Virginia courts have actually carved out an exception to that aspect of the arising out of requirement called the personal comfort doctrine. And essentially the personal comfort doctrine recognizes the need for periodic breaks and excursions for food, drink, restroom breaks, etc. So if you are hurt while going to get a snack or a drink of water from the water fountain or taking a quick bathroom break and something happens, you realize that could be compensable in Virginia. I've known people who somehow became convinced that wasn't really a work accident since they weren't really working, right? So at a minimum, it's worth filing a claim with the Workers' Compensation Commission. Similarly, what about employees who are injured while off the clock, right? Or off the clock going to work or coming from work, or that type of thing. Typically, if you think about it, that also would not satisfy the arising out of requirement. They're not even clocked in, right? Not clocked in, not doing any work really. Maybe getting ready to do work, or possibly not getting ready to do work if they're leaving work, right? And most of the time, you would be correct. Most of the time, and it's called the going and coming rule or the coming and going rule, depending on who you talk to. But most of the time, those going off the clock, going to and coming from work are not compensable because you're not doing work. That said, Virginia law has carved out some exceptions, three primary exceptions to the going and coming or coming and going rule. First, where the employee's means of transportation is provided by the employer, or the travel time is paid for or included in the employee's wages, the accident and resulting injuries may be compensable. Well, that kind of makes sense, right? If they're paying for you to get from point A to point B, like sometimes construction workers, depending on where the construction company is located and where the construction site is located, right? They may have to travel 45 minutes or something each morning and each afternoon. Well, instead of everyone taking their cars there, they may meet at work and travel in the van and that type of thing, right? So obviously that makes sense, okay? The second exception, where the accident occurs in a location such as a roadway or parking lot, that is the sole and exclusive means of ingress and egress, is the quote, by which all employees enter and exit the employer's premises. It may be compensable under those circumstances as well. And that makes sense, right? Think about it this way. The best example of that is an employee parking lot, right? But designated by the employer as the employee parking lot. A lot of times people will have to show an identification because there'll be a guard at the gate, or they'll just have to enter some sort of code to have the little arm kind of pop up so you can drive your car through it, right? So it's a parking lot specifically for employees. Employees have to park in that parking lot, right? Well, you can't require employees to park in a certain place, and then maybe the parking lot's icy or something during winter months, and you slip and fall. You just parked your car, you're heading into the building, heading into the main entrance, you parked it in the employee parking lot. The commission will, in the right circumstances, consider that to be a compensable work injury, even though you weren't on the clock or actually working at the time. So, and again, as with the last example, I've known employees to consider themselves, well, that I wasn't even working, I wasn't even clocked in, I'm not going to file a claim, that's not compensable, right? That's not necessarily the case, right? And some employees, you can sustain some significant injuries if you slip and fall in a parking lot. Parking lots are hard. So, and finally, the last exception, I should say, where the employer requires the employee to undertake a special errand, they call it, away from the employer's place of employment. The best example, a personal example of this is, I don't know how many times I've asked an assistant to run a pleading down to the courthouse to file it, right? Normally my assistants don't run around a lot. They're doing a lot of work in the office or research and drafting and this, that, and the other. So, but if I'm asking them to run down to the office, to the courthouse and file something, and they do it, and then they get rear-ended or they rear-end someone else, that would be a compensable. They're in the course of their employment, they're doing something that arises out of their employment, right? They're actually filing something. So that would also be arguably a compensable injury by accident in Virginia. The takeaway from all this is that injured workers should remember that they could still have a viable workers' compensation claim, even if, upon first impression, it may not seem in their head that they have a viable workers' compensation claim. And in the past, when injured workers haven't sought the advice or even a consultation with an attorney, and they just proceeded on their assumption, which was wrong, sometimes they haven't filed claims and the statute of limitations has run, and then they were out of luck. And fortunately, a lot of those injuries went away and resolved on their own. It wasn't that expensive, but there have been injuries that were expensive and just ongoing and lingering, and they couldn't get workers' comp benefits for it after the statute of limitations had expired. So, okay, another thing I wanted to talk about, which is kind of an exception to the arising out of requirement, is horseplay at work, right? Based on what we've just talked about in the arising out of requirement, you probably suspect that an injury resulting from coworker horseplay would not be compensable because it's not really connected to a risk or a hazard of the employment. And you should be right. However, the Virginia courts have carved out another exception to the arising out of requirement called the horseplay doctrine. And they've recognized that putting people together, even in a work environment, creates a situation where, and the quote is, workers, being what they are, fallible and sometimes playful human beings, will from time to time engage in pranks, some of which are dangerous, end quote. So basically, Virginia courts have reasoned that playful horseplay is a natural incident of work. It's a natural incident of putting people together in a place where they get to know each other and have personal relationships. So the rule is, an employee who sustains injuries during horseplay, when the injured employee is not participating in the horseplay, but is innocently injured by the pranks of other coworkers, has sustained a compensable injury by accident. A recent example of this was there was an employee who, worked there for a while and was friends with the coworkers who were working there at that time. Went back into the kitchen to fill up a bucket of ice, I believe it was, or something like that. And when he turned around at the ice machine, he turned around and he turned around because coworkers were flinging ice at him and hitting him. So he turned around and ice was heading towards his face, and I think he reached to block it. And actually, when he did that, he hurt his shoulder. So that was deemed, that went up all the way to the Supreme Court, I believe, and they consider that a compensable injury by accident. So that's another case where a lot of times I've seen employees, because they feel awkward because they weren't doing their job, right? And admitting that you were injured during horseplay means that you're admitting that you weren't doing your job. So a lot of times they won't file a claim because they don't think it's compensable because they were just horseplaying, and that's not necessarily accurate. So and a lot of thousands and thousands of dollars worth of workers' compensation benefits have been lost by assuming incorrectly that horseplay injuries are not covered. Okay, so last thing, I wanted to mention delivery drivers, because it's kind of delivery drivers is more understand, like, I think everybody, or a lot of people understand that if you're hired to be a delivery driver, that's your job. So if you get hurt, if you rear end someone or someone rear ends you, or you're making a delivery, it's a valid workers' compensation injury. I am aware of some people, though, that have kind of literally, non-attorneys, just injured workers, who have literally interpreted, like, you have to be hurt at work, right? So you have to be, like, delivery driver wouldn't be, injured. If you're injured while delivering, it wouldn't be compensable. But if you are at the place where the pizza's being made because you're at a structure, that would be compensable. That's not correct, okay? If you're a delivery driver, you're hired to deliver pizza. Like, that's your job, is to deliver. So if you're involved as a delivery driver, if you're rear-ended, if you rear end someone else, if when you're walking, not in your car, right, walking up to somebody's front door to deliver and you stumble in the yard or you slip on ice, or going back, if you're walking, that's also compensable. Okay, so that's an important note that I thought was worth mentioning, because some people misinterpret that. Oh, actually, I almost forgot. One other thing I wanted to mention is the situation of volunteering. Doesn't come up a lot, but does come up. Unfortunately, volunteers who are not paid or compensated are not considered employees under the Virginia Workers' Compensation Act. Now, when I say not paid or compensated, and that kind of makes sense, but when I say not paid or compensated, I mean not paid or compensated anything, right? So there's an issue where a volunteer does not get paid, but perhaps receives some sort of perks associated with their volunteering, right? Such as maybe somebody's volunteering to be kind of an usher, or be kind of the security person that checks tickets to an outdoor concert or something like that, right? You're just volunteering, you're not getting paid for it, but maybe the deal is, once you do that, you can go and observe the concert yourself, right? Well, arguably that's a perk that you receive. That's some sort of compensation, even though it's not money compensation, for doing a job, right? So if you were hurt while doing that kind of thing, say you went back to watch a concert and then someone else came up with the things, you got down to go check them in and you tripped and fell over the sidewalk while trying to hurry over to check somebody in. It's a good case that that's a compensable work injury in Virginia. So that's important to remember. Also, in certain circumstances, still on volunteers, in certain circumstances, volunteers who are injured while volunteering may be entitled to benefits if the business for which she or he was volunteering chose to include volunteers in their workers' compensation insurance policy coverage, right? If they included you in the coverage, then arguably you're entitled to the workers' compensation benefits, okay? And the third thing I wanted to mention about volunteers is, like, typically true volunteer firefighters, volunteer life-saving rescue squad members, again, if they're true volunteers, they're not entitled to workers' compensation benefits. However, some towns, counties, municipalities have passed a resolution or an ordinance electing to cover those volunteers. Well, when they've done that, then those volunteer firefighters and volunteer rescue squad members are in fact covered under workers' compensation. So that's important to remember, because you can obviously, I think everybody understands, you can sustain some significant injuries if you're a firefighter or you're a rescue squad, that kind of thing, because you put yourself in some dangerous situations. So that's important to remember. Along those lines, so that's all I have to say about the kind of the supplemental video about injury by accidents in Virginia. If you found this helpful, and I believe that it has helpful information in it, that's why I do it. Check out the website. Follow us on YouTube, Facebook, Twitter. I have informational videos. The website's chock full of information to help injured employees kind of get their bearings, know what benefits are available and how to try to get them, okay? If you found this helpful, and I think most people do, understand that if you found it helpful, probably other people will find it helpful, right? So tell your friends, tell your family, because they may know someone who, even if you haven't, they may know someone who suffered a work-related accident. Maybe their claim has been denied by the insurance claims adjuster, and they're kind of battling this. They're out of work and they have no income, and maybe they need some knowledge, right, to help them through. So feel free to share this with your friends. That's why I made this. I feel like it's always better to have the information and not need it than to need the information and just not have it, okay? I think that's all I got. Until next time, stay safe and don't get hurt at work.